For Botham John, the 26-year-old was shot last week by off-duty police officer Amber Geiger.
According to an arrest warrant, Geiger told investigators that she went to what she thought was her third-floor apartment. Instead, she went to John's fourth-floor apartment directly above hers. Geiger says her door was ajar and she saw a large silhouette inside. After giving verbal commands that were ignored, she fired her handgun twice, striking Botham once in the torso. It wasn't until Geiger turned on the lights and called 911 that she realized she was at the wrong apartment.
This fourth floor apartment instead of her third floor apartment. It says she tried to use an electronic key to open the door, but it was already open. She walked inside and told investigators it was totally dark when she noticed a large silhouette. Geiger says she thought John was a burglar and shot him after he ignored her commands. It wasn't until a 911 operator asked for her location that she says she noticed she was in the wrong apartment. So with
Attorneys for John's family say 2 witnesses told them details that contradict Geiger's account.
They heard knocking down the hallway, followed by a woman's voice that they believed to be Officer Geiger saying, "Let me in, let me in."
This is my key. This is my fob. I turn it, I open. Let me see if my door stays ajar. Nope. Lies.
Gilman, just about everyone by now has read this Texas Rangers arrest warrant. While the average person may not notice, criminal defense lawyers are reading between the lines, and they say from what they see, it may be difficult for the DA's office here to prove a crime. We asked several prominent criminal defense lawyers what they thought about the warrant. All of them were surprised. They didn't see words like reckless or intentional, which they say would normally be found on similar documents in manslaughter and murder cases.
It's an interesting read. I will tell you, it doesn't read anything beyond negligence, if that. They simply do not specify how she is reckless, which is the required culpable mental state for manslaughter. It reads much more like an accidental killing. I mean, it's simply if someone were to drop a gun accidentally and it fired and it hit somebody.
That attorney George Milner and others say this doesn't necessarily mean the prosecutors here don't have a strong case, because the investigation, of course, is still ongoing. But he says it's a clear sign that the Texas Rangers were careful not to implicate Officer Geiger. Live in Dallas, J.D. Miles, CBS 11 News.
Joining us right now is Barry Sorrells. He is a defense attorney and a former Dallas County prosecutor. You've been on both sides of things here, and I think it's really great to bring you in and sort of pick your brain about this case, because people have been really commenting a lot about this, keeping up with this. So much has been made about the charge that was initially made against Officer Geiger, the charge of manslaughter. Can you go into that a little bit? A lot of people thought that was a really odd charge.
Well, I think based upon what I know, besides reading the news reports and the stories that's been written about this case, I've also read the affidavit, sworn affidavit signed by a Texas Ranger in the search warrant to search Mr. Jean's apartment, also an affidavit in support of an arrest warrant to arrest Officer Geiger. And after reviewing all of that information, it's strange to me as to why at this point that she is being charged with manslaughter rather than murder.
A lot of people brought that up, and you, from a legal perspective, you see some issues with that as well. What are they?
Well, the legal issues I see is that if you knowingly and intentionally cause the death of another individual, you intend to do it, or you know that your actions are going to cause it, then that's first-degree murder. Manslaughter is second-degree felony, and the mental state is not knowingly, intentionally, it's recklessly, where you're aware of a known risk and disregard it. I don't see where that mental state applies here. It's like if you shoot at a fly on your wall with a gun, knowing that there's neighbors on the other side, and you kill somebody. That seems to be manslaughter. And I fully...
It's more reckless, you're saying.
Exactly.
Okay, reckless disregard, but murder would fit more when you know that you're actually shooting at someone.
That's right, and you knowingly, intentionally cause the death. And I expect, after further investigation, including the district attorney's office getting involved, that this case, my opinion is this case will come out of the grand jury, first-degree murder.
And then it'll be up to them to prove whether this was justified or not.
It'll be up to the defense at trial, which I fully expect that's where this case is going to go and should. It'll be up to the defense to prove through the evidence that this was justified under the law. And it would be a combination of mistake of fact along with justification for shooting someone that is burglarizing your place.
So just to be clear here, even if you make a mistake and you walk into someone else's apartment and you thought it was your own, you see them, you shoot them, you kill them, it can still be considered justified because you didn't realize you had made the mistake going into the wrong apartment.
Well, whether or not she believed in fact that this was her apartment, and I think that will be an important part of this case, but it's not conclusive that it was justified. You have to immediately believe that your life is in jeopardy. This is not self-defense. It's not defense of another person. This is based upon burglary at nighttime, stealing one's property, or the possibility of a felonious assault. You have to believe that to protect yourself from those things, that it became necessary at that moment to discharge your weapon. So even if the jury believes that she mistakenly thought it was her apartment, I think the issue is going to be what was going on at the time that she fired the weapon and the reasonableness of that. I mean, there's also, I think, the jury's going to take into consideration, could she have taken other more reasonable actions? The police department's across the street. She could have waited in the hall. She's armed. Is it safe to try and clear an apartment? The door was ajar, according to some reports I've read in the affidavit. I mean, do you go in or do you fall back and call for help? I mean, all of that's going to become relevant in this mix.
And a lot of people are going to be glued to this trial and
Fired cop Roy Oliver gives a first-hand account about the night he killed an innocent teenager, Jordan Edwards. It comes just one day after a grand jury indicted him for the youngster's murder.
Jason White joins us live. So, Jason, Oliver details what he says happened in today's court filing, right?
John, right now, this is the first detailed account we have heard from this former police officer. And in the court filing, Roy Oliver denies he did anything illegal. He says he's being treated unfairly and is considering asking to have his trial moved out of Dallas County. This isn't the criminal case against Roy Oliver. It's the civil one. The wrongful death lawsuit filed by the father of 15-year-old Jordan Edwards. In a 22-page response Tuesday, the former Balch Springs policeman gives his side, revealing he was the backup officer that night in April. And after hearing 6 to 10 gunshots outside a party, then a fleeing black Chevrolet Impala. The filing says that Oliver sees his partner, Officer Gross, move his weapon towards the rear passenger side window. Oliver hears violence, breaking glass at Gross's location. And in fear for himself and others, the filing says, Oliver fires his weapon into the car, 3 to 5 shots from approximately 10 to 15 feet and into the closed glass windows. The car was right beside the officers when the shots were fired. And Oliver says he specifically denies that he unjustifiably assaulted, killed Jordan Edwards, or anyone. And further, Officer Oliver denies that he violated anyone's constitutional rights. Jordan was a front seat passenger in that Impala. He was fatally shot in the head. Edwards' attorney blasted Oliver's explanation. This is the tried and true method for police officers getting off for committing murder without any real explanation, he said. Their facts have veered and they are completely fabricated and completely inconsistent with the investigation. This is the stuff of fairy tales, he told us.
We believe that we have a very strong case. We're going to be vigorous in our prosecution, and we're going to be very aggressive. So we're planning to win this case.
Mr. Brissett, Mr. Lane, if you would please rise for the reading of the verdict. This is cause number F1718595-V, the state of Texas versus Roy Oliver. The verdict form reads as follows. We, the jury, unanimously find the defendant guilty of murder as charged in the indictment. Signed by the presiding juror. Mr. Janacek, is that your signature?
Why do you know? Did this officer and Mr. John, did they know each other?
No one that I know who has a personal relationship with Botham can connect these two in any meaningful way. The only connection that we have been able to make is she is his immediate downstairs neighbor. And there were noise complaints from the immediate downstairs neighbors about whoever was upstairs, and that would have been Botham. In fact, there was a noise complaint that very day about upstairs activity in Botham's apartment. Botham received a phone call about noise coming from his apartment from the downstairs neighbor.
I see. And just lastly, as I